Hello, I hope you can see us and hear us now. My name is Patricia Netal, and it is my pleasure on behalf of the Wismut directors to welcome you to the final round of the 27th and first virtual Willem C. Wismut. Today is the last of about 560 virtual hearings that we have conducted in the last 5 days. If you would have asked the organizers 6 weeks ago if we think this is possible, my answer would have been a clear no. I'm glad that we gave it a second thought and made it happen. All of the teams and the arbitrators participating in this virtual Wismut brilliantly managed the technical challenges despite minor and sometimes major issues that came up. Congratulations to all of you. This final round is live streamed, and I hope that the audience can see and hear us and enjoy the oral hearing relatively relaxed in front of their screens. Today, there will also be a live stream of the award ceremony at 3:30 p.m. Vienna time, following this final round. It is now my pleasure to introduce the final panel and the teams that you will hear. The panel will be chaired today by Ms. Jacomine van Hersold van Hoof, Director General of the LCIA, whose rules are being used in this year's problem. Worth to mention that also the LCIA managed to convert into a remote working environment, with casework operating business as usual. Besides Jackie's institutional function, she is a professor of arbitration at the University of Leiden, has her own practices arbitrator in commercial and investment arbitration, sitting currently on several exit annulment committees. Before joining the LCIA, Jacomine had her own law firm in The Hague and worked with international law firms in the area of international arbitration. The second arbitrator is Professor Ronald Brandt of the University of Pittsburgh, also a long-standing member of the Moot family. He's a well-known scholar and lecturer on international and comparative law, author of numerous books and articles in major journals. He also co-founded the internationally recognized Center for International Legal Education at Pittsburgh University. He also supports many teams, also moot teams, and trains students throughout the Middle East and North Africa. The third arbitrator that I introduced to you is Professor Petra Butler from the Victoria University of Wellington, New Zealand. Petra specializes in domestic and international human rights, public and private comparative law, and private international law. Before joining Victoria University of Wellington, she worked for the New Zealand's Ministry of Justice Bill of Rights Human Rights team. Petra is a German fully qualified lawyer and a New Zealand qualified barrister. The teams that you will hear now is the University of Freiburg team representing claimant. Claimant speaker number 1 is Anton Augenstern and claimant speaker 2, Severin Burkhardt. Respondent in this arbitration is represented by the West Bengal National University of Juridical Sciences team. Respondent speaker 1 is Kaira Pinheiro. Respondent speaker 2, Ashka Jain. I will hand over now to the presiding arbitrator and wish you an enjoyable session. Good luck.
Thank you very much. Welcome, ladies and gentlemen. As we just heard, the first virtual Wismut. I'm delighted to open the hearings today in the proceedings between Hydro N plc and Turbina Energia Ltd Limited on the other side. I'm delighted to welcome the teams physically sitting in different parts of the world. And I would like to congratulate them, and if I may call it, their agents in organizing themselves in such a way that we are able to have this hearing as scheduled. Currently, we are seeing arbitrators, parties rescheduling hearings and struggling to do so sometimes. And it is amazing that you have managed to comply with the schedule and have our oral hearing today. At our hearing today, we're going to be hearing arguments both in relation to matters of procedure and substance. I would like to begin by asking both sides whether they have agreed on a structure and timing for today's hearing. Claimant,
Yes,
may I first?
Sorry. Now we have actually agreed on a procedure. First of all, respondent will start stating on the procedural aspects of the case, followed up by claimant. Claimant will then continue with the merits of the case, and respondent will end today's session by stating on the merits. And for each speaker, we have allocated a time of 14 minutes plus 1 minute of rebuttal. You're muted, Madam Arbitrator. I couldn't hear you.
And thank you. Respondent, is that also your understanding of the arrangements made?
Yes, Madam Arbitrator, it is.
Right. Well, if I might then make the following suggestion. The arbitrators have reviewed carefully, of course, the memoranda and the discussions so far. And in terms of procedural issues, there are really two distinct issues. One is the issue of jurisdiction and the asymmetric clause, and the second is the issue of the expert and the tribunal's power potentially to exclude the expert. We see these as distinct issues, and what we would suggest, with your approval, of course, is that we hear you separately on these points. And whether that means that you would like to change the sequence or have somebody else within the team address one or the other first is up to you. But also we would like to give you the guidance that, as far as we are concerned, we would prefer to spend the bulk of the time on the issue of the expert. So let's say 1/3, 2/3. And what we would like to do is have the rebuttal and surrebuttal insofar as you'd like to have it on each issue. For the substantive issues, we're happy to take them sort of in one go and rebuttal and surrebuttal as you have just suggested. Would you be amenable to this slight tweak to your proposal? Claimant.
Yes, of course, Madam Arbitrator, we are completely fine with that.
And respondent?
We are also fine with it. However, we would just like to clarify approximately what would be the time division then with respect to the speech?
Well, approximately the same as you proposed yourselves, that for the procedure issues together, we would still have half an hour, so 15 minutes per side, but we would hope that of the 15 minutes allocated to you, you would be able to address the jurisdictional issue in about 1/3 of that, and 2/3 then remaining for experts. All right?
Certainly, Madam Arbitrator. And just to confirm, will we be doing individual rebuttals with respect to issue 1 before we move on to issue 2?
Correct. That's the thinking.
All right, perfect. Thank you so much.
So who can I then give the floor, given this slight tweak to the schedule, on the issue of jurisdiction? Who's going first?
Would claimant be okay with respondent going first?
Yes, of course, claimant is fine with that.
Thank you so much.
Very well, please proceed.
Honorable members of the tribunal, good afternoon. My name is Kyra Pinero, and I, together with my co-counsel Ashika Jain, will be representing respondent in today's proceedings. I will address the procedural issues of the matter, while my co-counsel will address the merits of the dispute. Respondent has been brought before this tribunal today because of claimant coming under the unilateral arbitration clause. This particular clause provides claimant with the option between arbitration and litigation while denying respondent the same. It is our first submission in this regard that the tribunal lacks jurisdiction and that the unilateral arbitration clause is invalid. If I may come to the first issue first with regards to this, the jurisdiction of a tribunal must stem from a valid arbitration agreement. With that, I would like to refer the tribunal to page 13 of the record, wherein we see the arbitration agreement as entered into between the parties under Article 21, Clause 2. Therein, and if I may read for the tribunal, it states that the buyer has the right to refer any dispute arising out of or in connection with the contract to arbitration. Since the buyer is the claimant in the present case, we submit that this clause is on its face itself unilateral in nature. And because of this unilateral nature, we submit it is invalid for two reasons. Firstly, because it is violative of the principle of equality, and secondly, because it is contrary to the public policy of Danubia. Coming to my first argument first, Article 18 of Danubian arbitration law, which is the lex arbitrae in the present case, mandates that parties must be treated with equality. This is not only a mandatory provision of law, but in fact is one that cannot be derogated from by the parties, irrespective of their consent or their bargain. It is our submission here today that Article 18 stands violated since respondent does not have the right to apply to arbitration. If I may preempt the arguments that will be raised by opposing counsel, it is most likely that Article 18 must only operate during the proceedings in itself. However, members of the tribunal, the commencement of proceedings is said to begin on the date of the receipt for the request for arbitration. And since by virtue of this unilateral arbitration...
Counsel, if I may, even if that rule would apply to the clause itself, isn't it true that in today's commercial environment, there are many, many asymmetric arbitration clauses, and in some industries are just extremely common. So what is it that we should focus on that matters here in terms of the asymmetric arbitration clause? Are you suggesting that all asymmetric clauses should be invalid, or is there a test that we should apply and that would allow some to be valid and some invalid? And if so, what's that test and why? Which side do we come down on here?
Mr. Arbitrator, we submit that all unilateral arbitration clauses that are made under the lex arbitrae of the uncitral model law in specific ought to be rendered invalid by virtue of Article 18 being violated, since it is a mandatory provision. As I was stating...
Can I interrupt you here? You say
Indeed.
all countries that have adopted the uncitral model law, so that would include, for instance, German law.
Madam Arbitrator, the interpretation of Article 18 can vary. However, it is our submission that it should be interpreted expansively in the present case because, as was stated in the Uncitral Model Law Working Group Report number 246, paragraph 62, it said that this very same principle of equality must be observed not only by the tribunal, but also by the parties themselves.
But can we move from the abstract and the sort of initial normative thinking to practice? Because there are two schools of thought here, and there is case law going in both directions. And the suggestion that there is just one answer to this may not get us very far. Could you focus a little bit on some of the cases that suggest that it is more nuanced than you're now suggesting?
Indeed, Madam Arbitrator, there are several cases that support our stance, right from the Bulgarian Supreme Court de Cassation, which is case number 1193 of 2010, as well as the Sony Ericsson case, which is Russian Telephone versus Sony Ericsson. And while we admit that these cases, of course,
Sorry, counsel, to interrupt you there. The Sony Ericsson case, are you sure is that not distinguishable?
Indeed, Madam Arbitrator, I was just coming to that. Although the facts of the case are different, since in the Sony Ericsson case, both parties had the right to arbitrate, while only one party had the right to litigate, it is the ratio of the case that I present before this tribunal, which is that the principle of equality and real opportunity must be provided to both parties, and this opportunity should extend to the right to apply to a forum as well. And in this case, the word forum was used in both of these cases. They did not differentiate between litigation or arbitration in that regard. And hence we submit that since...
Sorry to interrupt you there again. Can I just... But don't you also think there is something like freedom of contract and that parties actually can decide themselves how they would like to draw up their contract?
Indeed, Madam Arbitrator. And that is a principle of party autonomy. And while we acknowledge that it is one of the guiding principles of international commercial arbitration, it nevertheless is not absolute. Party autonomy must be bound within the contours of equality in itself. And given that this equality is under Article 18, which stands violated, we submit that this party autonomy should be undermined just in the present case.
And picking up the facts of the case, I mean, again, you speak in abstract, but if we look at the negotiation history in this contract, this was a carefully negotiated clause. So can you shed any light on that, keeping in mind that you're rapidly using up the time allocated to your jurisdiction issue?
Indeed, Madam Arbitrator. If I may receive just 2 minutes to quickly wrap this up. Thank you. Coming to the issue of the fact that there was a negotiation, we completely agree that respondent did in fact consent to this particular clause. However, we submit that as per the commentaries as well as the working model law report, it states that irrespective of the party's consent, Article 18 must apply. And we submit that the time at which this clause was included was more from the perspective of the commercial bargain that was benefiting the parties, as opposed to the potential illegality of this particular clause. Given the fact that Danubia had no existing legal precedent with respect to unilateral arbitration clauses, the parties were treading on unexplored territory in itself. And for this reason, we submit that irrespective, given the fact that Article 18 must apply, the unilateral arbitration clause must be rendered invalid. To quickly come to my last point, with regards to the Danubian public policy and the unfair effect of it. The courts of Danubia have upheld the case of Siemens versus Dutco, which is a French Supreme Court decision in itself, which stated that equal treatment of parties is of crucial importance. Now, the tribunal has a duty under Article 32.2 of the LCIA rules to ensure an enforceable award, and awards may be denied recognition or enforcement under Article 5.2b of the New York Convention. And since we submit that the procedural rights of respondent in the present case, by virtue of their disadvantage at the stage of commencement of proceedings in itself stands at a lower position with regards to claimant, we submit that this unilateral arbitration clause should therefore be declared invalid, since should an award to the contrary be rendered, it could risk being unenforceable as per Danubian public policy. If the tribunal has no further questions, I would like to conclude.
Thank you so much. Claimant.
Thank you, members of the tribunal. Quickly reintroducing ourselves to you. My name is Anton Augenstein, and I will be presenting the procedural issues today. Unfortunately, not next to me, but still with us is my co-counsel Severin Burkhardt, who will elaborate on the merits of the case. And together we're here on behalf of our client, Hydro EN, who is the claimant in this arbitration. Now, members of the tribunal, opposing counsel tries to invalidate an arbitration agreement that both parties consented to. On top of that, it now even tries to introduce an expert that puts a danger on this lawfully constituted arbitral tribunal. And on that note, I would like to make the following two submissions: that the arbitral tribunal does indeed have jurisdiction to hear the case, and second, that the tribunal is kindly requested to exclude Professor John from these proceedings. Now, coming to my first submission, the arbitral tribunal does have jurisdiction to hear this case. I will, contrary to what the opposing counsel stated, show that the principle of equal treatment in our dispute does not even apply at a stage when an arbitration agreement is concluded. In my second point, I will address that the principle of equal treatment is in any case not violated by this arbitration clause. And in my last point, I will address the issue raised by opposing counsel that the public policy of Danubia in our case is not violated. Now, coming to my first point, the principle of equal treatment does not apply in our case. Members of the tribunal, claimant does not contest that the principle of equal treatment is an important principle. However, the question is whether this principle can override a principle that is just as important, namely party autonomy. And this is not the case, as the systematics of the Danubian arbitration law, which is a verbatim adoption of the ancestral model law, show. I would therefore like to draw the tribunal's attention to Article 18 of the Danubian arbitration law that is located in Chapter 5. And if you would just be so kind to indicate when I can proceed.
Yeah, please proceed. But I'm a little mystified by what you just said. Did I hear you suggest that in general, in abstract, the principle of equal treatment is less relevant than party autonomy, just across the board? Was that your submission?
No, Madam Arbitrator, not at all. We are submitting that the principle of equal treatment and party autonomy must be balanced, and in our case, it is party autonomy that prevails.
Okay, and you're going to explain why that is, because I'm mindful of the time here as well.
Of course, Madam Arbitrator. I can quickly just stick to that point. Now, the principle of equal treatment would override party autonomy in cases where parties are in different, unequal bargaining positions, where parties are commercially experienced, however, and were in strong bargaining positions during the negotiations, then party autonomy prevails over the principle of equal treatment. And as it is the case in our dispute, we have two very sophisticated, commercially experienced parties that were very well aware what they were getting themselves into when negotiating that clause. And therefore, the trade-off that the parties actually had and where clauses were exchanged against each other can be perceived on page 32 of the record in paragraph 6, where I would like to draw your attention to.
Sorry, I might have misunderstood. Just to clarify, so you're not making an Article 18 argument, are you? You're making a different argument on a really kind of discrimination, non-discrimination argument, what the presiding arbitrator, as Ms. van Hustel has said before. Is that correct? Or are you agreeing that Article 18 applies?
No, Madam Arbitrator, we actually submit that Article 18 is a mere procedural right that only shall preserve the party's integrity during the proceedings. As already pointed out by opposing counsel, the parties shall be treated with equality by the arbitral tribunal and not shall treat each other equally. And actually, Chapter 5 of the...
Excuse me, counsel, even if it's a procedural right, there must first be procedure, isn't that correct? And if we put together Article 21.1 and 21.2, we see that claimant can go either to court or arbitration. Respondent really can't go anywhere where their choice will be honored, because even if they go to court, it's subject to the claimant's right to pull them into arbitration. So the respondent has no choice that they can go to where they are sure that the forum will hear their case. Now, doesn't that create some real problems here that go simply beyond either equality or party autonomy? It gives him no right to access to justice, does it?
Mr. Arbitrator, I totally see your concern. However, first of all, I want to point out that respondent consented to that when negotiating the clause. And second, there are no issues with respondent's access to justice. Now, of course, there is a limitation of respondent's access to justice. However, that limitation is not that severe, as respondent can either refer disputes to the state courts of Mediterranean, or it finds itself in front of another judicial body, just as this arbitral tribunal, granting both parties a fair trial and a reasonable opportunity to be heard. And from that, we conclude that there is no issue with respondent's access to justice, which would actually lead me to my next point.
Yeah, keep in mind that you're already basically running out of the time that we would have allocated you given the preponderance of the expert issue.
Of course, Madam Arbitrator, just one quick question. I thought that we have concluded that it would be around 9 or 10 minutes for the first issue. Isn't that correct? Or
that is incorrect. That is in total, right?
Oh.
I mean, you have half an hour for two sides, so.
Of course. Then, Madam Arbitrator, I would just like to point out that Danubia's public policy is not violated, as there is no violation of the principle of equal treatment in our case, and therefore the arbitral tribunal does have jurisdiction as we have a valid arbitration agreement. And just to quickly clarify, then I got 3.5 minutes time left. Is that correct for the second issue?
No, I have lost you. What you refer to as the second issue is the expert issue. Yes, I can hear you. Can you hear me?
Yes, now I can hear you again.
Okay, so when you say second issue, you refer to the expert issue. Is that correct?
Precisely, yes.
Yeah, okay. Once we're done with this round, we will start again. So we're not adding the time necessarily to that, because I think we are losing a little bit of time with the video and all that. So you have 1 more minute if you wish to make any final comments in relation to the jurisdiction point, and otherwise I suggest we proceed if there's any rebuttal on this issue.
Of course. Thank you, Madam Arbitrator. Then I would just like to point out one more thing that opposing counsel raised, namely case law. And as Mr. Presiding Arbitrator has already raised the concerns that there is arbitral tribunals or courts that validate asymmetrical arbitration clauses and courts that do not do so, this is a very controversial topic, and we have to decide it on a case-by-case analysis. And just to name a few model law adopting countries, Singapore or France, for instance, have held that arbitration agreements such as the one in our case are valid. And looking at our case, there is no problem with neither the principle of equal treatment nor respondents' access to justice. And from that, I want to conclude that the tribunal has jurisdiction to hear the case. Thank you.
Thank you very much, respondent. Would you like a quick rebuttal?
Yes, please, just a minute if possible. Okay, I'm beginning. Opposing counsel has based all of his argumentation on the fact that the bargaining positions of the parties were equal and that we consented. However, both of these elements are entirely irrelevant in the light of a procedural right violation. And thereafter that, opposing counsel conceded that at the commencement stage, respondent is disadvantaged. Article 21 of the model law, which defines commencement of proceedings, is also placed under Chapter 5, titled Conduct of Proceedings, thus pointing to the fact that our procedural rights have been violated. Thank you.
Thank you very much. Claimant, Sir Rebuttal?
Yes, thank you. Members of the tribunal, to clarify, we do not say that the trade-off balances or equates the validity of the clause, but we say that this clause is asymmetric, therefore, however, not invalid. And when looking at the negotiations and the clauses that were exchanged against each other, it becomes apparent that this exchange of clauses balances the asymmetry of the clause. Thank you.
Very well. We then move on to the issue of the expert. Now, who wants to go first on this? Because I can imagine that it might make sense to change the sequence here, but I'm in your hands.
Madam Arbitrator, I would just suggest that as we are claiming the exclusion of the expert, then we would go first on that issue.
Respondent, how's that? Does that work with you?
Yes, it does.
Okay, thank you. Please proceed.
Thank you. Now, members of the tribunal, first of all, I will show that Professor John, the expert retained by respondent, should be excluded from these proceedings as he compromises the composition of this arbitral tribunal. In my second point, I will then address that respondent's right to present its case would not be violated, and that Professor John is not independent enough from respondent, thereby also justifying an exclusion. Now, coming to my first point, Professor John can be excluded as there is a conflict of interest in our dispute.
Can I interrupt you there?
Sure.
When you say compromises the constitution of the tribunals, you can imagine if there's one thing that troubles arbitrators, it is concerns about the constitution of the tribunal. So if there is an issue with the constitution of the tribunal, is that not the starting point? Should we not first look at the arbitrators and whether there is anything that needs to be done about their position on this tribunal?
Madam Arbitrator, of course, one always has to have a look at an arbitrator. And what respondent stated, that it would take Ms. Burden, the arbitrator appointed by claimant, under close scrutiny, is something that runs counter to that what you just mentioned. An arbitrator's impartiality, of course, is something important. However, where the addition of an expert leads to the question itself, whether the composition of the tribunal is endangered, in that case, we have to look at whether this expert could compromise the composition of the tribunal, and therefore, as it is the case in our dispute, Professor John can, due to such conflict of interest, be excluded. That will lead me to my first point. Now, first of all, the tribunal has the power to exclude party-appointed experts from the proceedings. Article 20, subsection 3 of the LCAA rules gives the tribunal the power to allow, refuse, or limit oral and written testimony of expert witnesses. Now, unfortunately, that that provision lacks any further guidance as to when an expert can be excluded. And to be clear on that, we do not want to apply Article 18, subsection 4 of the LCAA rules directly or analogously. We merely want to use the rationale behind that provision to support Article 20, subsection 3 with the lacking guidance and with the guidance that it seeks. Now, coming to that, the rationale of Article 18, subsection 4 is applicable as it shall preserve the integrity of arbitral tribunals. Now, even though it explicitly refers to legal representatives, where the introduction of a participant into the proceedings bears the risk that due to a conflict of interest between that participant and a member of the tribunal, the composition of this tribunal can be compromised, then an exclusion of the expert is warranted, as party-appointed experts can, in the very same manner, compromise the composition of an arbitral tribunal. And Professor John, in our case, compromised the composition of this tribunal. Now, respondent has stated in a letter to the LCAA court, without any further legal relevance, that it would take Ms. Burden, the arbitrator appointed by claimant, under close scrutiny and see whether her behavior reveals a lack of impartiality. Even though at the moment, and that is quite likely that opposing counsel will argue that, there are no grounds for an exclusion apparent, it still might come up that leaving Professor John in these proceedings will cause a conflict of interest, and therefore that the risk of the tribunal's composition being compromised would still remain, thus justifying an exclusion of the expert appointed by respondent.
Sorry to interrupt you again, but I'm still not completely clear where you're getting at with this point. If we were to decide that we are not going to request the expert to step down, would then your submission be that the arbitrator needs to be challenged?
No, Madam Arbitrator. If Professor John is excluded from these proceedings, then the tribunal would actually exclude somebody that is, so to say, a trigger for respondent that can constantly be pulled.
Yeah, I know, but if we decide against you, what's the consequence?
You mean if you decide against the request for an exclusion of the expert?
Correct.
The consequence would be that leaving Professor John in the proceedings bears the risk that a challenge will later on be called by respondent to the arbitrator, Ms. Burden.
Yeah, that's what I'm trying to understand from you. Are you saying that if we do not request Mr. John to step down, you are bringing a challenge? We
would bring a challenge not to the arbitrator, because that is the arbitrator appointed by our own party. Ms. Burden was appointed by.
But that's why I'm trying to get at what your interest is here. I know what you're requesting initially, but if we were to find against you on this point, how would you like us to proceed? Isn't the corollary of our potential decision then that the arbitrator would have to step down? And are you then not shooting in your own foot?
No, because there would be no justifiable doubts as to Ms. Burden's impartiality left. And of course, should respondent find that there are, apart from the connection between Professor John and Ms. Burden, still justifiable doubts left as to the arbitrator's impartiality, then of course an exclusion, or pardon me, a challenge would be warranted. That would be fine. However, again, leaving respondents Professor John in these proceedings should actually not be tolerated, as it bears the conflict of interest between the expert and Ms. Burden. Now, if you would
could I just stop you there? Because for me, you're just arguing at the moment a little bit in the abstract. Could you just clarify where you see the conflict actually? Where is it?
Of course, Madam Arbitrator. The conflict of interest at the moment is not apparent, to clarify that. However, Professor John, being in these proceedings, would provide respondent with a, so to say, as already outlined, trigger that respondent can constantly pull to provoke a behavior of Ms. Burden, especially regarding the outcome of the patent litigation going on between her husband and Professor John, that respondent could invoke and therefore, could come to a conflict of interest. And
so you phrase this differently. So my understanding is from the record that the husband and Professor John have a dispute about $5,000 or pounds. Yes. And I'm sure one of us arbitrators, we earn that in a day. So where is the conflict?
Madam Arbitrator, merely referring to the 5,000 annual turnover of Ms. Burden's husband does not already show us where the conflict of interest lies. The conflict of interest, and one has to bear in mind that a risk to the composition of the tribunal is enough. The conflict of interest here lies within the possibility of respondent managing to provoke a behavior of Ms. Burden that may subsequently lead to a challenge, or at least give grounds for a challenge to the arbitrator. And quickly addressing the other point that I would like to make, the respondent's right to present its case would in any case not be violated by an exclusion of Professor John. There are 3 other experts available that have comparable qualifications as Professor John. And the mere fact that Professor John currently works at the Riverhead Tidal Power Plant does not make him the only one who is able to assess whether cavitation and corrosion could have an effect on our power plant, or how the power plants in Greenacre and Riverhead are comparable. And from that it follows that the tribunal could replace Professor John with any of the other experts, and therefore respondent's right to present its case would not be violated by me.
But wait. You want us to replace a party-appointed expert?
Madam Arbitrator, we kindly request the tribunal to exclude Professor John from the proceedings. And if I was mis-expressing myself there, respondent could appoint another expert that is equally qualified as Professor John. I'm sorry for that.
Okay. Thank you. Right. You have about 1 more minute left if you so wish. Otherwise, we will move on.
Thank you. I would like to take that minute. Now, Professor John, in addition to all of that, is not independent enough from respondent. While we would agree that Professor John, as a party-appointed expert, does not have to meet the highest degrees of independence, as for instance, tribunal-appointed expert, Professor John still, due to the connections with respondent, is not independent enough to provide a completely objective opinion. Professor John and respondent share a connection that goes back more than 15 years, and back in 2004, respondent was so impressed by Professor John's work that it decided to hire 2 of his assistants that are now at the 2nd management level of respondent. In the course of this close contact, respondent even invited Professor John at the Hydro Energy Fair 2013, where Professor John justified why respondents' turbines were so great that they justify a higher price as their direct competitor. And as if this wasn't enough, in 2018, Professor John even seized the opportunity to talk to one of his former assistants, thereby stating that he's not, showing that he's not independent enough from respondent. And this would actually conclude my submissions. Thank you.
Thank you so much. Respondent.
Can everyone hear me? Okay, may I begin? I'd like to start off by addressing opposing counsel's 3rd submission first, and then going to his 1st and 2nd. He suggests that Professor John is not independent or objective enough in his opinion, and for this reason, the report must be preemptively excluded. However, we suggest instead that the tribunal may admit Professor John's report, and under the authority provided to it under Article 22.1 Clause 6, the tribunal may decide upon the authenticity and the weight to allot to that particular report in itself. There's no reason to preemptively exclude it on this presumption. If I may now come to opposing counsel's 1st submission with regards to Professor John's relationship with Mrs. Claire Burden amounting to a conflict and alleging that it compromises the tribunal. Members of the tribunal, the mere existence of a relationship in itself does not amount to the existence of a conflict. Opposing counsel seems to have fallaciously equated the two. In fact, as was stated in both the Russell trading case as well as the ASM shipping case, it was stated that professional association, particularly in specialized fields, is extremely common and does not make for a case of a lack of impartiality in itself. As we can see from the fact that there exist only a total of 4 experts in the field of turbines who speak English, we see that this is indeed a very specialized field. And for this reason, the mere association of the two does not amount to a conflict in itself. In fact, as was rightly cited by Madam Arbitrator, tribunals are typically apprehensive to exclude party-appointed experts in particular, since a considerable amount of time, money, and effort goes into their appointment, as well as familiarizing them with the manner and the circumstances of the dispute, as was stated in the Medtronic healthcare rehabilitation case. It is for this reason that we submit that the tribunal must think twice before preemptively excluding our expert without even looking at his report. While we acknowledge the fact that Professor John is indeed engaged in a patent litigation against Claire Burden's husband, we do not feel at all that this in itself amounts to justifiable doubts, and for this reason are not choosing to challenge this relationship at this present stage.
If I could interrupt you here, I mean, the flip side of my questions to your colleague, I hear what you're saying, but at the same time, should we not be especially cautious? And given that we are at the starting point of these proceedings, isn't there a lot to be said for being safe rather than sorry, and recognizing that there's not a huge field, but still that we could make arrangements that would preempt difficulties? And then ask you also to comment on what I just asked your colleague. Are we building in a challenge effectively if we proceed as you would like us to proceed?
Madam Arbitrator, we submit that we are not building any such kind of questionable factor into the present dispute, since Mrs. Claire Burden herself has stated that she is merely aware of this association but does not feel that this clouds her judgment whatsoever or affects the proceedings. The commonality of such relationships is what we base our arguments on, and the fact that the tribunal must respect the respondent's right to properly present their case. This has been provided under Article 18 of the Uncitrall Model Law, as well as Article 14.4 of the LCIA rules, wherein the tribunal has the duty to ensure that a party has a meaningful opportunity to present their case. And such meaningful opportunity, as was stated by Professor Weinsheimer, extends to the ability to present material and relevant evidence of one's own choice. Professor John is the best man for the present dispute for a variety of reasons. Not only was he appointed as the independent advisor at the Riverhead Tidal Plant, which is the plant that claimant alleges bears linkage to the present case due to the extreme corrosion that occurred there, but he is also the representative for the R27V Francis turbines, which are the turbines present in the present case. It is for this reason that apart from the fact that he is extremely experienced in itself, he is intimately associated with every aspect of this dispute, ranging from the production process of steel to the difference in corrosion caused by salt water versus fresh water. And while we acknowledge that there do exist 3 other experts in this particular field, we submit that none of these 3 experts have ever worked with the respondent before, which means that they are completely unfamiliar with any of the facts and circumstances of the dispute, as well as the design and specifications of the turbines.
Excuse me, can I interrupt you again to go back to the previous point? And I'm doing so recognizing that my colleague is sitting next to me, and I will spare her the discomfort potentially of raising this question. But are you suggesting that on the point of the potential impact on the independence of the arbitrator, we should rely on the words of the arbitrator, that there's nothing that we need to be worried about? Is that supposed to satisfy us? Shouldn't we be guided by more objective criteria as to independence? And if so, could you direct us to the sources?
Indeed, Madam Arbitrator, it is our submission that there exist 2 sources for this. Firstly, a challenge may be placed upon Mrs. Claire Burden under the LCIA rules, imputing that there exist justifiable doubts. However, these justifiable doubts, as was stated by both parties, do not exist at the present case in itself. Secondly, if you would like to even refer to the IBA rules, we submit that enmity between an arbitrator and an expert is enlisted under the orange list. However, we submit that there exists no enmity in the present case, since, as was pointed out by Madam Arbitrator, the worth of the entire year for the patent litigation is $5,000, which is equal to be precise, 10.5 hours of the tribunal's time. It is for this reason that we believe that this is far too trivial for it to amount to an actual conflict, as claimant is conflating the issue to be. It is our submission that claimants...
Sorry, Counsel, to interrupt you there, but can that really be the test? How much money are at play? Isn't there a little bit more at play than that, than just money?
Indeed, Madam Arbitrator, and while we submit that there is more with respect to reputation or feelings of bad faith between the 2 of them, nevertheless, we submit that Professor John and Mrs. Claire Burden have never had any negative interactions in the past, nor have any reason or have even a direct interaction, since it is Mr. Burden that is engaged in the litigation against Professor John. we believe that the prospect of this challenge is extremely remote in itself. And the tribunal must balance this probability against its duty to ensure our right to properly present our case, which takes me back to my submissions about why the other three experts simply will not suffice. While we acknowledge that these three experts have comparable qualifications, they have no familiarity with the present dispute. And this takes me to my last submission, which is the tribunal's duty to ensure expedient and efficient proceedings. Under Articles 14.2 and 14.5, the tribunal has been vested with the widest discretion to ensure fair, expeditious, and efficient proceedings. And members of the tribunal, if I could take you to page number 45, which is procedural order number 1, to be precise. Under Roman numeral 2, point number 2, we see that the expert Professor John has already completed his report. And if I may now show you the point just below that, we see that the tribunal needs to render an award by the end of April if respondent is to be able to deliver the replacement turbines for claimant by September 2020. Given that we are already in April, urgency is of the primary concern in the present case. And Professor John, just to clarify, took 7 months to make this report. If we were to preemptively exclude him at this stage, and thereafter that substitute him with any of these other three experts, this would bound to result in a delay, and this delay is very tangible as opposed to the potential but not probable challenge that claimant alleges we might make against the arbitrator in the future. For this reason, to quickly summarize, we submit that Professor John should not be preemptively excluded for 2 reasons, because firstly, it violates our right to properly present our case. And secondly, because it violates the tribunal's duty to ensure efficient and expeditious proceedings, given that these experts will obviously be bound to have to start from scratch with respect to their reports, entirely derailing the timeline on which this tribunal needs to operate, given the urgent circumstances. Thank you, members of the tribunal.
Thank you very much. Claimant, rebuttal?
Yes, thank you. Members of the tribunal, the mere fact that Ms. Burden, and I quote opposing counsel there, does not feel that a conflict of interest could arise, does not change the fact that respondent, after claimant has nominated its arbitrator, has introduced an expert into these proceedings that, throughout the whole procedure here, serves as a potential ground for a challenge, as the patent litigation between Professor John and Ms. Burden's husband is still ongoing. Thank you.
May I respond?
Please.
Members of the tribunal, we could not possibly have appointed Professor John any earlier than we did, since he was appointed within our response for the request for arbitration. There was no way for us to have appointed him at any stage prior to that, since the dispute in itself hadn't arisen. And claimant cannot allege that we intentionally appointed Professor John to infuse a questionable factor, since he has been our party-appointed expert for all disputes since 2005. And as I had stated, a single party-appointed expert is preferred because of his unique perspective and close familiarity with the circumstances. Hence, we did not do this with any malified motives whatsoever, and thus, for this reason, the opposing counsel stands rebutted.
Thank you so much. We will now move to the second part, which I anticipate will go somewhat more swiftly, because we will not be forcing you to cut up the argument in 2 pieces. So over to claimants, I suppose, on this one.
Thank you. Ms. van Hersolte van Hoof, Professor Butler, Professor Brandt. My name is Severin Burkhardt, and I'll be speaking on the merits of the case on behalf of claimant. So in spring 2018, respondent delivered 2 Francis turbines to our client. Subsequently, however, it turned out that respondent's main steel supplier had delivered defective steel to respondent. Consequently, the turbines delivered from respondent to our client are strongly suspect of being defective and potentially endanger the entire power plant in which they are used. In these extraordinary circumstances, we asked the tribunal to find first that turbines are non-conforming under Article 35 of the CISG, and second, our client is entitled to request substitute delivery of the turbines pursuant to Article 46, paragraph 2 of the CISG. Coming to my first submission, the turbines are non-conforming as they are not fit for their particular purpose. Article 35, paragraph 2, letter B of the CISG reads that goods do not conform with the contract unless they are fit for any particular purpose expressly or impliedly made known to the seller. And members of the tribunal, if you would be so kind to turn with me to page 11 of the record, which is the sales agreement, to illustrate what the purpose of the turbines was. And if you could indicate when you're there, that would be. Thank you. And the sales agreement you have in front of you, I would first to point out that this entire sales agreement was conditional upon our client's contract with Greenacre. Without the contract with Greenacre, this sales agreement would have never been signed in the first place. And if you have then a look into the last recital of the preamble, which is the block text, it reads, Francis Turbines, which due to its characteristics complies with the requirements and considerations as set out in the tender, meaning the Greenacre tender. And if you have a look then further down on the page, Article 2, which states the seller's obligation reads, in paragraph 1, letter A, the seller undertakes to support the buyer in its participation, and then further confirming its commitment to the project. Members of the tribunal, from these lines, respondent knew or could not have been unaware that the purpose of the turbines was not just to support our client to win the tender, but actually to fulfill the contract with Greenacre. And the turbines are not fit for the purpose to fulfill the contract with Greenacre, as my following arguments will show. We know from the procedural order number 1 from the appendix 2 that the likelihood that the turbines are defective lies at 75%. We also know from the Riverhead incident that defective steel can lead to the destruction of an entire turbine. And this, as we know from the record, can lead to the destruction of an entire power plant. As a consequence of these high risks posed by the turbines, our client's power plant is not in line with Greenacre's green energy strategy. And as a result, and this is the disaster.
Excuse me, counsel.
Please.
If I understand your argument correctly, you're saying first that the respondent took on the claimant's obligations as to the Greenacre contract, and I'm not sure I quite understand that. But then second, that the particular purpose here, and I'm still a little vague on that, is to comply with the Greenacre contract, but still we have speculation and uncertainty, don't we? What is the standard that of proof that's required under 35(2)(b) here, and how is it met in this case, and why isn't it is not just speculation?
Mr. Brandt, let me address this question in two parts. First, we are not submitting that the opposing party took over the entire risk between our client and Greenacre. Rather, what we are saying that we have communicated a particular purpose, and then the seller takes over the risk that the goods are in fact fit for that particular purpose. And therefore, the opposing party is liable that the turbines are in line with the Greenacre green energy requirements. And coming to your second point, why they are not, we know from the procedural order number 2 that Greenacre now has the right to terminate the contract with our client due to the strong suspicion of the turbines, and has already threatened to do so. And that's such an infringement of contractual interest on our side.
But still, it seems to me the purpose under the Greenacre contract is to provide energy that's not from fossil fuel sources. And the goods are doing that at this point, and there's no proof that they won't continue to do that. So I'd like in a couple of words, what is the particular purpose here? Just saying that it's compliance with the Greenacre contract doesn't seem to get me there. What is the purpose, and why is it that even though the turbines are working, they are non-conforming?
Mr. Arbitrator, I understand your concerns. However, it is the purpose of the turbines to be in line and therefore enable our client to fulfill the contract with Greenacre. And that this is possible as a particular purpose is also showcased by case law under the CISG, namely...
Sorry, as a counsel, I just interrupted you. Sorry about this. But the turbines are fulfilling the contract. They are at the moment exactly doing what they're supposed to do. So I'm following my colleague, Professor Brandt, that I'm still very unclear what the particular purpose purpose really is you're referring to.
Of course, Professor Butler. If I might quickly come back to my first point and then answer your question. Professor Brandt, our point is that under the CISG, as showcased in the inflatable arch case, we can have recourse to a third party, which then can be incorporated the requirements of the third party into a sales agreement. This was showcased in the inflatable arch case of the Commercial Code of Argo in 2002. And Professor Butler, the turbines are not doing what they're supposed to do, because in our position, what they were supposed to do is enable our client to stay in the contract with Greenacre and remain in the requirements set out by Greenacre. And as we know, the turbines are not doing that, as the Greenacre has the right to terminate the contract due to the strong suspicion and has already threatened to do so. And that such an infringement of contractual interest on our side renders goods non-conforming under Article 35 of the CISG is showcased in the frozen pork decision of the Federal Supreme Court of Germany in 2005. And this decision...
sorry, Counsel. How does the frozen pork case has any relevance in these proceedings?
Professor Butler, we are referring to the frozen pork case because the court explicitly stated that the decisive factor for finding when a suspicion can be equated with an actual nonconformity is that the suspicion alone infringes on the purpose of the goods and therefore on the contractual interest of the buyer. Comparably, in the case at hand, the suspicion alone has seriously infringed on the purpose and therefore on the contractual interest of our client, as it could not fulfill the contract.
In the frozen pork case, the suspicion related to problems that could affect human health, and people's own health could have been affected by that. That's really not what we have here, is it? Isn't that case clearly distinguishable from this case?
Professor Brandt, it is our submission that it is, of course, that we have different setups and different goods which are traded. However, the threshold which was applied can be applied to the case at hand. And the decisive question is the good still fit for its purpose, despite the suspicion? And the CISG does not distinguish which goods are traded. It merely looks whether the good is still fit for its purpose. And it is not fit for the purpose in the case at hand, as Greenacre now has the right to terminate the contract. And therefore, we are seriously infringed on the contractual interest of our client due to the suspicion alone. And with that, I would like the tribunal to imply the standards set out in the frozen pork decision and find that the turbines are non-conforming under Article 35, paragraph 2, litera B of the CISG, which brings me to my second submission, that our client is entitled to request substitute delivery pursuant to Article 46, paragraph 2 of the CISG. This provision requires a fundamental breach, and the parties have defined their own standard for a fundamental breach in Article 20, which is found on page 13 of the record. And although Article 20 is headline termination for cause, it must also be applicable to substitute delivery. This is because the CISG tries to uphold contracts as long as possible and gives the buyer the right to terminate the contract only as a last resort. Therefore, if this article gives the buyer the right to terminate, it must even more so give the buyer the right to ask for substitute delivery as the less severe remedy. And under Article 20, paragraph 2, litera D, the breach committed by the opposing party is fundamental, as our client is deprived of what it was entitled to expect under the contract, which was to fulfill the contract with Greenacre. And this will have...
Excuse me, but didn't your client limit itself to damages under Article 19? Isn't that a derogation from the opportunity to have specific performance?
Mr. Arbitrator, it is correct that we have a limitation of liability cap in the contract. However, they are only referring to damages and not to other remedies such as termination or substitute delivery. Otherwise, Article 20, which refers to termination, would be completely irrelevant, as termination would cost the opposing party $40 million US.
But the title to that article is limitation of liabilities. It seems to me liability can be damages, they can be specific performance, can they not?
Mr. Arbitrator, we agree and share this understanding. However, a reasonable person would not think that the parties have excluded another article which they included in the sales agreement, which is Article 20, which gives the buyer the right to terminate the contract, which would cost $40 million US, and therefore over the liability cap. And therefore we submit that due to the damage clause, we cannot reasonably come to the conclusion that other remedies are excluded. And
so can I interrupt you here? Because I have a question which I'd like you to address, not just in rebuttal if it comes to that, but it's the Article 22 entire agreement clause, because as you can hear from the questions, we're a little bit troubled about your linkage to the other contract, and I'm particularly troubled when I see this Article 22.2. So I'd appreciate your guidance on its meaning and scope.
Of course, Madam Arbitrator, I have 2 points on this question. First, in Article 20, paragraph 2, it reads, "This document contains the entire agreement between the parties." And the preamble I was referring to is part of this document. And second of all, according to the CISG Advisory Council opinion number 3, an entire agreement clause does not preclude to have recourse to commitments and agreements before the signing of the sales agreement. Rather, it only precludes to have recourse to commitments after the signing of the sales agreement. For example, this could be the penalty clause our client entered into with Greenacre, which is barred for this interpretation. And coming back to my point, why our client is deprived.
Sorry. The point about this document, I mean, that's a very narrow reading of the phrase "this document." I mean, surely this document means the document and the wording in it. And the wording in it describes, to a certain extent in the preamble, this other contract, but there is no incorporation by reference.
Madam Arbitrator, even if we were to follow that we could not directly refer to the preamble or other sentences in the contract to explain the particular purpose, we could still have recourse to the agreements between the parties in accordance with Article 8, paragraph 2 of the sales agreement. And I would like to point out that Article 35, paragraph 2, letter B of the CISG only requires that the purpose must have been impliedly made known to the seller, and therefore we submit that we have made the purpose expressly clear, as there was no alternative use for the turbines without the power plant of Greenacre. And if I might ask for an additional minute to quickly and then wrap up.
Yes, sorry, I didn't mute my line, so I may have been causing the interference. Yeah, please proceed.
Thank you very much. If the opposing party does not replace the turbines, our client will face 3 detrimental consequences. The first one is our client will be deprived of its expectation of being able to generate revenue for 3 years uninterruptedly. We will have downtimes between 2 to 12 months within the first 2 years alone, which will lead to a loss of revenue of up to 7.2 million in the first 2 years of operation. Secondly, our client will face reputational damages, as our client could not comply with the requirements of Greenacre. This will become public due to the heightened political and public pressure on the project, and future customers will then think twice before contracting with our client, bearing in mind that our client built a power plant which involves 2 Francis turbines, which have a likelihood of being defective of 75%. And thirdly, our client is in a very weak position in its contract with Greenacre, with the constant risk that Greenacre goes forward and terminates the contract. And this is so tremendously harmful for our client, as the average construction costs of a power plant, which involves 2 Francis turbines, is between 100 to 300 million US dollars. And these investments will become tremendous. Please.
You now state explicitly that in the contract vis-a-vis Greenacre, your client is in a weak position. But isn't that a problem of your own making, that you're squeezed between a contract where there is this weakness that is simply not there on the face of this other contract? So how should we read in? Why should we read in such a fundamental different perspective on the contract than the wording justifies?
Madam Arbitrator, it is our submission that we have not to read in the particular purpose as I've mentioned, because we have several references in the preamble and in every single of the seller's obligations to Greenacre. And it was clear from the very first day that there is no alternative use for the turbines, instead without the power plant for Greenacre. Therefore, we have made it expressly clear that this is the purpose. And if I might direct you to page 33 of the record, why we are now so squeezed in the position and why replacement is so necessary for our client. And after that, I would quickly wrap up my arguments. On page 33, the third paragraph and then the third line from the bottom, it reads, Mr. Crutzen, the Greenacre counselor in charge of the program, made clear that any other solution than immediate replacement in 2020 is unacceptable for Greenacre and would probably result in the termination of the contract between Greenacre and Hydro-EM. Therefore, members of the tribunal, our client is deprived of what it was entitled to expect under the contract, as we are in a very squeezed position right now. And therefore, we have a fundamental breach. And to conclude my second submission, therefore, our client is entitled under Article 46, paragraph 2 of the CISG to request substitute delivery. Thank you very much for your time.
Thank you so much. Respondent, over to you.
Am I audible? All right. Good afternoon, members of the tribunal. My name is Ashika Jain, and I shall be addressing the merits on behalf of the respondent, Turbina Energia. There is a suspicion of defective steel having been used in the turbines. There are suspicions as to the negative consequences that may arise due to this initial suspicion. While the claimant claims a replacement based on mere suspicions, the respondent has some concrete facts to provide at the present juncture. The turbines have been functioning flawlessly over the past 18 months, and the claimant has faced no discrepancies in its operation whatsoever. Over the course of the next 14 minutes, I shall be responding to the submissions made by my opposing counsel to establish that first, the turbines delivered by my client are conforming under Article 35 of the CISG, and second, that my client is not obligated to deliver replacement turbines under Article 46, Clause 2 of the CISG. Addressing my submissions. Members of the tribunal, opposing counsel based his submissions on under Article 35, Clause 2, Subclause B. However, I would like to state that this provision is not applicable to the matter at hand. This is because if we read Article 35, Clause 2, Subclause B, it states that the seller is required to deliver goods which conform to the particular purpose of the contract, except when it can be seen that the buyer did not rely on the seller's skill and purpose. In the present situation, I shall present before you facts which shall show that the claimant did not rely on the respondent's skill and judgment. First, if I may turn the tribunal to page 4 of the record, paragraph 1, it clearly states that the claimant is a world leader in producing hydropump power plants and operates in over 100 countries. Furthermore, if I can draw your attention to page 10 of the record, the third paragraph, last line. It clearly states that the respondent had made certain suggestions as to the construction of the hydropower plant, but the claimant had outrightly rejected them because of financial reasons. It has been stated, members of the tribunal, that a refusal of the seller's suggestion as to the use of goods shows a lack of reliance on the buyer's part. Thus, I would like to submit that the case at hand falls...
Excuse me, counsel. Am I not correct that your client charged a 10% premium based upon what was represented as the much higher quality of the turbines here than is normal? And does that not reflect something about seller's skill and judgment for which the claimant paid extra money here? How is that not reliance on the seller's skill and judgment?
Mr. Arbitrator, this is because the claimant has been purchasing such turbines since a very long time in order to carry out the operations of all of its hydropower plants. Furthermore, in the present situation, even if we say that the claimant did rely on us based on the fact that we charged a 10% higher price, the fact that it refused several of the suggestions that were made by my client, which would enable the continuous availability of the plant, shows that this case does not fall under Article 35, Clause 2, Subclause B. Having said that, I would state that Article 35, Clause 1 is the relevant provision for this case. A suspicion of defects in order to amount to a nonconformity under Article 35, Clause 1 is required to be based on concrete facts. And secondly, the usability of the goods in question should be affected. I get this threshold from the chip tuning case, wherein there was a suspicion of increased wear in the engine of a car. And this suspicion had arisen because the usability of the car was affected. And
Excuse me,
since
counsel,
in that case,
if I may, because the claimant is not relying on 35.1, it seems to me that I'm not sure why we need to address that, but I'd like to stick with what the claimant did argue, and that's 35.2b. And it does seem to me there is a particular purpose here. If you look at Article 2.1e of the contract on page 12.
yes, Mr. Arbitrator.
It does say that the seller, in effect, was going to enter into a separate agreement, but was to ensure minimum interruption. And we already know that we've moved the schedule forward for inspection. There's going to be interruptions that were not anticipated. Isn't that a particular purpose here? The whole purpose was not to have interruption that would require use of fossil fuels. And now we already know there will be that interruption. Isn't that A, a particular purpose, and B, a failure to comply with a particular purpose?
Mr. Arbitrator, for the sake of convenience, I would like to proceed with my submissions under Article 35, Clause 2, Subclause B. In this case, I would state that the particular purpose of the contract has been fulfilled by virtue of the fact that the turbines are indeed producing energy at the required rate of 600 megawatt, and the claimant is essentially reaping profits out of it by selling this energy to the city of Greenacre. Now, responding to my opposing counsel's contention based on the fact that there is a 75% probability that the turbines might be defective, I believe that my opposing counsel gets this figure from Appendix 1 on page 55 of the record. However,
but counsel, sorry to stop you there. Is that actually relevant? Because whatever the suspicion is, the fact is that now everything has to be, as my co-arbitrator already pointed out, it has to be done beforehand. It has to be stopped, with the uncertainty what will happen. Isn't that already a breach?
No, Madam Arbitrator, we submit that in the present situation, the uncertainty is not to that extent, which becomes a reasonable certainty and fulfills the threshold required for suspicion to amount to a nonconformity. My opposing counsel's contention was based on the fact that the primary steel supplier of the respondent might have was the fraudulent steel supplier supplying defective steel. However, if I may draw your attention to the second procedural order, page 51, paragraph 31, it clearly states that different turbines produced by the respondent are made from different batches of steel. And at the time of production of the turbines for the Greenacre power plant, adequate amount of steel from other suppliers was present and could have been used to produce the turbines. Now, my opposing counsel also mentioned the Riverhead incident in order to say that there is a probability that the turbines at the Greenacre plant might also be damaged. However, I would like to submit that comparing the Riverhead plant to the Greenacre plant is like comparing apples to oranges. This is because physical factors such as density and salinity of water are very specific to each plant, and factors affecting one plant might not affect the other. This is buttressed by the fact that the Riverhead power plant operates in salt water, which has a much higher corrosive effect on the steel as compared to fresh water, which is the condition at the Greenacre power plant.
Counsel, can I interrupt you here? I hear your submissions on, let's say, the level of suspicion, and you make some arguments why maybe there's less reason to be concerned about the situation than your opponent suggests. But picking up my co-arbitrator's point, isn't it clear that the current situation is in any event factually incomparable with the situation that was contractually foreseen with the maintenance methodology and time schedule that was built into the contract? So in that sense, it's not a matter of suspicion whether it's a high probability or a low probability. It is simply a different factual matrix. Could you focus on that, please?
Yes, Madam Arbitrator. It is indeed quite unfortunate that due to the additional documentation created by the certification agency, my client is unable to provide authentic quality certificates to guarantee the quality of steel. And in order to fulfill this very purpose, that is to verify the quality of the steel, that the inspection of the turbines has been preponed from 2021 to 2020. Now we acknowledge that this inspection will be carried out over a period of 2 months and might cause a downtime in the Greenacre power plant. However, we submit that the claimant has consented to this inspection, and it is for the benefit of the claimant itself, in order to remove all uncertainty surrounding the situation, that the respondent has agreed to even incur all the costs for this inspection.
Sorry to interrupt you again, but that's a pretty far-reaching argument, because basically what you're saying is what your opponent is doing is reasonable mitigation. They're working with you to make the impact as small as possible, but that doesn't take away the primary point that there is a need to address the non-conformity that there is in the first place. I mean, you can refer to certification issues or other issues, but doesn't that go back to Professor Brown's point that there is potentially not conformity as prescribed by the contract?
Madam Arbitrator, whenever there is a case of suspicions amounting to non-conformities, it becomes a non-conformity under the legal provisions only if the seller is unable to dispel the buyer's suspicions. In the present situation, an inspection is the way by which the claimant's suspicions regarding the quality of steel can be dispelled, and this is why the inspection is indeed important. Now, before I proceed with my submissions under Article 46, Clause 2, I would simply like to bring the tribunal's attention to page 53 of the record. Members of the tribunal, opposing counsel had umpteen number of times laid stress on the Greenacre government's threat to terminate its contract with the claimant. Under paragraph 42 on page 53, the fifth line from the bottom, beginning with furthermore, it states that furthermore, while Greenacre Energy in principle has the right to terminate the contract for cause, it is unlikely that it will do so in the present case. This is because there is no other alternative source of energy at present. This means, members of the tribunal, that Greenacre government's threat to terminate a contract is merely a threat that will indeed not materialize. Having established this, I would like to respond to my opposing counsel's claim regarding a replacement of the turbines. Now, my opposing counsel turned the tribunal. Yes, Madam Arbitrator, if I may ask for an extension of another 2 minutes, so I could speak till 16 minutes. Thank you. My opposing counsel turned the tribunal to page 13 of the record to contend that the threshold for fundamental breach has been lowered from that of a substantial deprivation to a mere deprivation. However, as the heading of Article 20 clearly states, termination, and the placement and the position of the lower threshold of fundamental breach as a subclause to this article clearly shows that the parties intended to lower the threshold only for termination and not for replacement. Thus, in order to be entitled to a replacement of goods, the claimant has to fulfill the threshold under Article 25 of the CISG, which is that of a substantial deprivation. Having said this, members of the tribunal, I would like to state that in the present situation, there is a great probability that the turbines are completely flawless. And further, the most reasonable remedy that should be resorted to is simply an inspection of the turbines. Members of the tribunal, the CISG is based on the concept of mitigation of costs, wherein if there are two remedies, both of which are
Excuse
adequate.
me, counsel. I believe that in the procedural order, we've basically taken the position on the fourth issue that we assume that if there's breach, there should be a remedy. And the question is, what should be the remedy? And so let's assume for purposes of the fourth issue that there is breach. Why would replacement not be appropriate?
Mr. Arbitrator, just to clarify your question, is your question that the inspection will lead to a result that there is a non-conformity in the turbines or a breach at the present moment?
I'm assuming that if we answer the third issue by saying there is a breach, that then we have to find a remedy.
Yes, Mr. Arbitrator. Well, Mr. Arbitrator, as specified, a breach in itself does not entitle a buyer to a replacement of goods, because indeed it is a very expensive remedy. And in order to be entitled to it, the buyer has to prove a fundamental breach of contract. A fundamental breach is one which greatly endangers the buyer's purpose of retaining the goods. And in the present situation, that is not the case because the turbines are functioning absolutely flawlessly. Now, before I conclude, if I can finally bring the tribune's attention to page 55 of the record, that is Appendix 1. On this page, the parties have demonstrated the costs associated with the different remedies. We see that the cost of a minor repair or major repair are $10.2 and $16.7 million. The cost of an inspection being even lesser. As compared to this, a replacement of the turbines shall cost a total of $36 million to my client. Members of the tribunal, a cost of $1.2 million compared to $36 million, which is for the replacement of the turbines, seems to be an extremely onerous burden on my client, especially in a situation when the turbines have not shown even a single sign of corrosion or cavitation till date. Hence, I would like to conclude my submissions by saying that all that my client seeks is one opportunity to inspect the turbines. And as a result of that inspection, if such a finding is made that the turbines really require an immediate replacement, my client, as previously promised, shall be willing to incur the entire cost for it. But at the present juncture, since that threshold has not been met, my client is not entitled to replace the turbines. Thank you, members of the tribunal. If there are no further questions, I shall rest my case here.
Thank you so much. Claimant, rebuttal?
Thank you. The opposing party stated that our client could not rely on the skill and judgment because our client did not build a larger generation building as suggested. However, this larger generation building would have only facilitated inspection and minor repair works. It would not have had any effect on the actual quality or reliability of the turbines. Therefore, our client could indeed rely on respondent skill and judgment to deliver 2 Francis turbines which are reliable without a likelihood of being defective of 75%. Thank you.
Thank you so much. Respondent?
Members of the tribunal, this has been stated by Professor Schwenzer, who is a renowned scholar on the CISG, that whenever a buyer rejects the seller's suggestions as to the use of the goods or with respect to the maintenance of the goods, it shows non-reliance on the seller's skill and judgment. Here, this building could have facilitated faster inspections and faster repairs, clearly showing that they would have played a role in the usage of the turbines. Thus, I would state that in this case, the claimant did not rely on the respondent's skill or judgment. Thank you.
Thank you so much, counsel, for your clear and persuasive submissions. Colleagues, do we have any final questions at this stage, or is it time for us to withdraw?
I have no further questions.
No, I don't have any further either. Thank you, counsel, for your submissions.
Counsel, thank you so much indeed for your submissions, for your fantastic virtual submissions. The tribunal will now withdraw, and the instructions we have been given are that we will reconvene at 3:30 Vienna time when the tribunal will come back with its decision, and we will have the closure of these proceedings. Thank you very much, and we look forward to seeing you shortly.
Thanks to all
Thank
of
you
you.
so much.
Thank you so
Thank you
much.
very
Have a
much.
good day.
Bye-bye.
Bye.
Goodbye.